Okay, what is the difference between statute law and common law? Alright, statute law is decreed, it's written down on paper by councils, and common law is a little more flexible than that. You could notice the difference that common law is for the people, it's decreed by the Constitution. It's a proclamation that everybody is their own sovereign person and can serve their own courts as needed, but it may not have the power that statute law has with the courts. Statute law can be found more in the lower courts. Common law can be exercised more in the upper courts. Okay, so there's statutes that the lower courts follow, and it's a little less flexible. The judges are less aware of common law at that lower level. So if you try to argue common law in a statute level, it's going to be more difficult because a lot of times they may not understand what you're talking about. All right, common law tends to focus on the cases. It's also known as case law, but that doesn't entirely cover common law. People argue that common law is antiquated. It's like an old system, but it really makes law a little more fluid. It seems to me like it's the type of law that runs around the gears of statute law. If we let statute law prevail, it would lead to a dictatorship. All right, because anybody in power can decree certain laws. Like they don't like pink shoes, and make their fines known, maybe put somebody in jail for a few years based on the statute laws. And the statute laws are getting pretty bad, just with curfews and all that, in my opinion. But you can kind of debate that a little bit with common law. If you have a case, there's, like for my example, I have the disorderly conduct, and although I'm not exactly sure how I bring common law into it entirely with the statute law, there are some like techniques I can use, like also do a reverse type of not lawsuit, but I can do a counterclaim with the accusations by the prosecutor, and my counterclaim can challenge jurisdiction. Okay, that's a common law defense. And then I could exclaim that I am of the people of Idaho in a court of record, and then I may want to make this motion or that motion. There's a little more flexibility with the common law, and you don't really have that flexibility especially on the cop level. It's like the policeman level, when they write tickets. That's pretty much statute law. They just kind of interpret it, but they don't theorize on the law. They just kind of do what they're paid to. And then even the lower appellate courts, they rely on statute law and then take care of just pushing people through. And it seems like the court system is based on a level of intimidation and expedience, because they deal with so many people, and they don't want to put up with major defenses. They just want to get to the facts. Just stick with the the facts. You were at such and such place at such and such time. Now, I think there are some aspects of law that can be used either way with statute or common law, in that you can appeal to the senses, like with the evidence. Like, I heard this person say this type of thing, or I heard just some weird noise, but I didn't quite see it, like that helicopter. Now I see it. But also I can include a sixth type of feeling, which is what was going through my mind at the time, how it made me feel. I'm a little annoyed by the helicopter. The feeling is pretty helpful for describing how the situation is. So that's probably, the senses are probably something you can use for both statute laws. It's just to tell a story. But with the two laws, they're kind of opposing each other. You don't want to take over the courts by installing common law. You're still following court rules. You'd almost consider having like being two courts. You have your court where you can hold the judge accountable, hold the prosecutor accountable, hold the clerk the clerk accountable, and you want to make sure that you have a good game, you put on a good show, and then when you ask the clerk, you don't for information, or you're trying to find something out, you don't ask them how to do something, because they're not able to legally give you legal advice. But if you ask the question in a different way, such as what do you require to have such and such a done, then they're more willing to help, because then they're not giving you legal advice. So if I wanted to make a motion for a counterclaim, I'd ask them, what do you need to have to file a counterclaim, instead of asking how do I do a counterclaim. There's a difference in questioning there.